Listen, losing someone you love is, well, it's incredibly hard. And in the middle of all that grieving, the absolute last thing you want to deal with is a confusing maze of legal paperwork. But getting a certified death certificate, that's a non-negotiable step to finalize their affairs. Doing this efficiently doesn't just, check a box for the state. It actually brings you some much-needed peace of mind when you need it most. And we totally get the frustration here. Bureaucratic red tape can feel so overwhelming, especially when you're already dealing with a massive emotional toll. But the state does have strict rules, and they're there to protect sensitive identity information. That's why they don't just hand these documents out to anybody who walks through the door. But here's the good news. Once you understand the framework the state uses, the whole thing becomes entirely manageable. Okay, let's dive into this and break down exactly how you can successfully obtain a death certificate in Nebraska. Here's our quick roadmap for today's explainer. We're going to cover why you need this record, the legal hurdle, standard versus abstract certificates, the step-by-step process, costs and pitfalls, and finally, resources and final tips. Section 1. Why you need this record. Let's start with the practical reality. Why is this one specific piece of paper so incredibly critical right after a passing? Basically, a certified death certificate acts like a master key for handling major legal and financial transitions. You literally have to physically present this document to various institutions. For example, life insurance companies. There is no way they'll pay out a policy without seeing a certified copy. If you're settling an estate, going through probate, or just trying to transfer the title of a car or a house, the courts and the DMV absolutely require this proof. Same goes for closing bank accounts or dealing with Social Security and pensions. Because you have to send these out to so many different agencies at once, executors and families usually need to request several certified copies right out of the gate. Section 2. The legal hurdle. Who actually qualifies? Because this document holds so much legal power, Nebraska has some pretty strict privacy laws about who can access it. So, the crucial point is, you can't just request this on demand. Under Nebraska law, you have to demonstrate what they call a proper purpose. That means you need a legally recognized, tangible interest in the record. Now, immediate family members, so a spouse, parent, child, or sibling, they automatically have a proper purpose. But if you are an immediate family, you have to prove your legal authority. Say you're the executor of the estate or a lawyer for the family, you have to submit explicit documentation proving your legal standing before the state is going to hand over that certificate. Section 3. Standard versus abstract certificates. Now, what's really interesting about this slide is a critical update that just went into effect in July 2024. We now have a standard certificate and a new abstract of death certificate. Here's how it works. If a death is pending an active investigation, meaning the exact medical cause hasn't been finalized, the state can now issue an abstract of death. This is a game changer because it allows families to start closing bank accounts and transferring car titles without waiting months for an investigation to wrap up. But, and this is a huge but, the abstract completely omits the cause of death. Because of that, it is totally invalid for life insurance claims. Life insurance companies strictly require the standard certified death certificate that fully discloses the medical cause. Knowing exactly which one you need will save you massive headaches down the road. Section 4. Step-by-step process. Okay, let's talk execution. How do you actually get this document into your hands? We've broken down the bureaucracy into 4 easy chunks. Step 1, gather the specific info, the deceased's full legal name, date of death, and the city or county where they passed. Step 2 is proving who you are. Step 3, downloading and filling out the official application, which is Form NEHHS 92. You can grab that right off the Nebraska DHHS website. The form just asks for the deceased's details, how you're related to them, and your proper purpose for needing the copy. Finally, step 4 is submitting the whole shebang, the completed form, your supporting documents, and the required fee. I actually want to pause on step 2 for a quick second because it is absolutely crucial. Nebraska enforces really strict identity verification. If you're applying by mail, you have to include a photocopy of a current, unexpired, government-issued photo ID, like your driver's license or passport. And listen, this photocopy must be perfectly legible. If the Vital Records Office gets a dark, blurry, or smeared copy of your ID, they will halt your application right then and there. Once you've got your form filled out perfectly and your ID copied, you've got 3 ways to submit. You can just drop it in the mail to the Vital Records P.O. Box in Lincoln. If you're in a rush, you can physically go to the Vital Records office in Lincoln in person. Or, if you'd rather handle it digitally, you can submit the request online through an authorized third-party service called VitalCheck.
That route lets you pay with a credit card and gives you tracking features, though keep in mind, it does come with some extra processing fees.
Section 5, Costs and Common Pitfalls. Speaking of fees, let's look at the financial side and how to avoid the mistakes that get applications rejected. The state statutory fee is exactly $16 per certified copy, and that's true whether you're getting the standard certificate or the abstract. Now, if you're mailing this directly to the state, you have to pay by check or money order made out to Vital Records. They do not accept credit cards through the mail. As for processing time, expect about 10 to 15 business days, but if you're in a real hurry, that online Vital Check service does offer expedited shipping.
And this brilliantly illustrates what happens when you don't provide the exact documentation the state wants. Look at this real September 2024 response from Nebraska Attorney General's office. It's about a guy named Gary Wilson. Mr. Wilson applied for his deceased brother's death certificate because he needed it for probate proceedings. He sent in his ID and he proved he was the brother. But the Vital Records office actually deferred his application. Why? Well, to act in a legal capacity for probate, just being a brother isn't enough. The state needed him to submit official letters of appointment from the court, proving he was literally named the legal administrator of the estate. Without that specific proof of legal authority, his whole application stalled out.
So the huge takeaway from Mr. Wilson's case? You have to prove your proper purpose right up front. Double-check Form HHS 92 to make sure every single box is filled out accurately. And if you are applying as an executor, a legal rep, or an attorney, do not forget to attach those court documents, like letters testamentary or letters of appointment that explicitly prove your legal authority over the estate.
Section 6, Resources and Final Tips.
Let's wrap up this explainer with some actionable advice. If you have a super complex case, or you're just not quite sure what documents you need to prove your proper purpose, please don't guess. Reach out to the Nebraska DHHS Vital Records team directly. You can call them at 402-471-2871 or just shoot an email to dhhs.vitalrecords@nebraska.gov. Getting the answer straight from the source is going to save you so much time. Also, just a quick but important reminder before we finish. The information we're sharing in this explainer is purely for educational purposes. It is not legal advice. Estate laws can get pretty nuanced, so always consult official Nebraska state sources or talk to a legal professional to get guidance tailored to your specific situation. Dealing with the loss of a loved one is a massive emotional weight, and staring down a stack of state paperwork, that can absolutely feel like too much. But armed with the knowledge of how that proper purpose doctrine works, knowing the difference between the standard and abstract certificates, and understanding exactly what ID, forms, and fees you need, you are more than capable of navigating this. So what do you think? Could taking this organized, prepared approach be your first confident step towards settling their affairs and ultimately finding some closure? Thanks for learning with us today.